certain materials bait stamped in the notice of discovery 28. It's a little difficult for me to figure out whether this is entirely new based on the chart or whether it's some similar document or similar information, but in a different form or what have you. Yeah. But take any line, you know, I mean, right. Take Bates number 114 towards the bottom of page 13. Mm-hmm. I guess it's item 114, Bates number 228 to 232. Milton Police Department incident report is the way it's identified. Right. And there's an indication here provided to Attorney John Geary. Correct. So it looks to me like you're saying that this document, although recently produced by ADA Hickman, was previously produced by ADA Lally.
To the prior council.
To prior council, and presumably to this council also, because I'm sure all the documents were, all the discovery was reproduced when new council came in. So I don't know if there's a dispute about whether item 114 in discovery packet 28 is or isn't different.
Correct.
That's what I'm trying to get my arms around.
I understand that, Judge, and we've gone through those, and we've pulled them, and we've pulled out the original that we got in 2021, if there actually was an original, and then we'll put it together with what we got in 2025. So we've done that for a number of items in that chart. I think maybe all of the items in the chart, except for the videos. We haven't compared the videos because we'd be here till next year trying to compare the videos.
Some of the videos are video clips that were produced originally, and they've given you the whole video. And I guess I don't know if that matters. You know, obviously you now have the whole video. It would have been good if the whole video was produced, but oftentimes there's all 12 seconds in a video that matters, and you know, it's hard to know whether the omission of the entire video matters.
Understood.
So, you know, if I were to go through the first 6 items here on page 13, for example, of Mr. McKee's memo, how do I figure out whether it is or isn't different? I mean, do you also have a spreadsheet that would sort of match up here and describe what's different or what's not? Or are you just doing sort of
document?
Okay.
We were going to ask witnesses, but now I understand the court doesn't want us to do that. I'm happy to.
You could, okay, you could, but we'll be here until the cows come home. And I don't know when the last time there were cows in Dedham, but you know, bottom line is there probably is an easy way to figure out or to sit down and coordinate what isn't new and what's not, and then figure out whether it matters.
And to this point about, and you mentioned the word matters.
Well, that's prejudice.
Yeah.
Okay, that's whether there's prejudice.
All of the cases cited by both counsel, myself and Attorney Scaficcio, talk about individual documents that were provided midstream in a trial or right before trial or after trial. There hasn't been an articulation of what of any of these documents prejudices the defendant. And I just can't, I've attempted to provide Your Honor with some kind of macro areas that were new and explain them, but I don't know, I can't respond to what I don't know. I don't know which of the documents that were newly provided prejudice the defendant such that the public doesn't view a public trial. And that grave and extreme remedy. Since this motion's been filed, the Commonwealth and the defense jointly requested that the defendant's bail be reduced to $2,500. Judge set it at $10,000. He's posted it. The trial is off the list. What I'm trying to understand, and I'd ask the court to order it, is if we're going to meet about, I would like to know which of these documents in a pleading prejudices the defendant, so I can respond to it. I have police here to explain some of these macro issues, but I did that almost as anticipatory and trying to help the court, but I don't know even what they're asking or suggesting is prejudicial to the defendant and would prevent him from having a fair trial.
Okay.
So So, Judge, I think you're right. There are two issues here. There's their failure to produce Rule 14 discovery, which could result in sanctions other than dismissal. And I think that's an easier question, because that's all the notices of discovery that ADA Hickman put together, where she noted specifically, this was not provided before, this was provided before. That's easy for the Commonwealth. It's their document. They gave it to me. So they shouldn't be confused by what they gave me and they identified as new. If they're now saying some of the stuff that ADA Hickman said was new isn't new, then they got to tell me about that, because that's what they had represented and that's what ADA Hickman had represented when she took over. So to the extent that we all need to sit down, I'm happy to do that, Judge, but there's two different lines of questioning here. One is, where's the stuff been since 2021? Because my client was in custody for almost 4 years, awaiting trial, and we had a September trial date. And then, where's the prejudice? So they're jumping all the way to the prejudice, and we still don't have our arms around where's it been since 2021.
Right. So before I deal with the prejudice issue, it seems to me that I ought to know what is new and what you think is materially new. Okay? And I know that puts a burden on everybody to work together, but it seems to me that we ought to do that. I have two other matters on this morning, so we're gonna break by 11:30 today, okay? I think I can begin by taking evidence on the question of where has this stuff been and why wasn't it turned over earlier? And we're gonna have to adjourn. We're not gonna finish this today. And in the interim, I can have you folks get together and do a comparison to figure out, this is new because it has somebody's handwritten notation in the upper right-hand corner. This is new because it's the full unredacted video, and the redacted video of 12 seconds is the only relevant portion, or whatever, okay? And we can get our arms around materiality, we can get our arms around prejudice, and maybe it will also focus some of the attention on why wasn't this turned over. Because it may be that this is all stuff that was annotations in one person's file. I don't know, you know. I'm not saying that's the situation, but it'll focus us a little bit. But it seems to me we can use the morning well by beginning on the first question, which is why wasn't this turned over in a timely manner? How do you want to proceed on that score?
I would then call ADA Lally first, because he was the first one to touch the file, Judge.
It's the defendant's burden. Certainly it's our motion, counsel's motion. I do also have here, just for I have two Milton police officers and state police, Lieutenant Tully, that I would offer the court to explain the Milton aspect, and the items that ADA Hickman produced after going to the Milton Police Department and copying paper files and receiving an electronic file from them.
Okay.
That would take care of a bulk of what ADA Hickman provided in the spring of this year.
Why don't we start with ADA Lally?
Sure.
Okay. And it may be that you also want the talk to the Milton people.
Well, I'd ask that everybody, all the witnesses, be sequestered, Judge.
That makes sense.
That's fine.
Okay.
And they've been here all morning.
And
May I approach on behalf of ADA Lally?
sure.
Briefly. Judge Attorney Pat Hanley on behalf of ADA Lally, who's...
Oh, you're near a microphone. You're good. Okay. Go ahead.
Okay.
Give me your name.
Patrick Hanley on behalf of ADA Lally.
Okay.
I had filed, I think, either Thursday or Friday, and served upon the Commonwealth and Attorney Scapiccio a motion to limit or perhaps modify the format of any presentation by ADA Lally. ADA Lally is an officer of the court. ADA Lally, I anticipate, is in a position to answer many of the questions that you have or that are raised by defense counsel, but that he should do so from counsel table and address them directly rather than in response to questions. I suggest that it will be faster. He's prepared to do it, and if there's follow-up questions that the court has or that are derivative from defense counsel's motion, I suspect that he'll be in a position to answer them. And so I'd suggest that be the format.
Why?
And because it will be faster. It also obviates the need to examine defense counsel to the extent there's any question of what was sent to defense counsel before or what was raised in documents before, defense counsel, I would suggest, shouldn't be on the witness stand, and he shouldn't be on the witness stand. The last thing I would say is, if the court is inclined to put him on the witness stand, I'd ask for the opportunity to, at the conclusion of defense and Commonwealth's questioning, to question him and raise anything that has not been raised in his testimony by that point.
The motion is denied. Mr. Lally can testify like any other witness. He has relevant testimony. He's being called as a witness, and he can testify as any other witnesses. Lawyers do it all the time. ADAs do it all the time. Defense attorneys from time to time do it.
Sure.
Okay, and so we can proceed.
May I, well, I'll say this. The Commonwealth has filed motions to quash, and one of them partially with ADA Lally. And this goes back to my initial point about narrowing the scope here and focused on the discovery issues at hand. ADA Lally is subject to a protective order on another matter, and I would ask the court to review the Commonwealth's motion to quash, and if we are taking a break here, and preclude counsel from inquiring about those issues that he cannot testify to and will not testify.
If there's a protective order issue, we'll address it, okay? And if he feels like he can't answer a question because he's subject to a protective order in another matter, we'll deal with it.
Thank you.
Okay.
And the other part of this is, these were, and I'll just pass them up to Your Honor. These were the subpoenas that both ADA Hickman and ADA Lally received from counsel, seeking production, and probably dovetails with counsel's request for all the emails. I would ask that the court quash in so much as the request for the file and any work product and anything that goes beyond Rule 14, mandatory discovery, anything that involves work product, mental impressions, or anything of the such, should not be part of this questioning.
So right now, part of this questioning is, what did this ADA know?
Right.
What did he do?
Thank you.
Okay, who did he talk to? That's arguably work product. It gets discovered in this context, because the question is, why wasn't this stuff produced in 2021? I understand that could be embarrassing for the office. I understand that could be embarrassing for certain individuals. That's where we are right now in this particular case, because lots of stuff from 2021 wasn't turned over, okay? So it may be that emails become relevant to this testimony, okay? Who knew what when, and what did they do or didn't do in order to follow up? So I'm going to have to deal with this on a question-by-question basis. I cannot quash it across the board,
Correct.
all right?
And I would agree, Your Honor. I actually, to that point, I have included emails to explain the issues at hand. So this is not, when I can understand an issue, I provided the emails to help explain it.
Okay, all right.
Thank you.
ADA Lally, you're on.
Yes. Mr. Lally, if you could come forward to be sworn.
I apologize. We have witnesses here. You want them?
Sequestered, yes.
So counsel's also, we have a motion to quash this subpoena entirely. ADA Hickman, do we want ADA Hickman present for this questioning?
I do not, Judge. She's going to be a witness as to what how the condition of the file as she found it. I don't think she should listen to what Lally says he had in the file before she testifies. That's no dispersion on ADA Hickman at all, Judge.
I understand. I'm going to overrule the request for sequestration of ADA Hickman. She's counsel of record now, and an officer of the court, and I'm confident that we do not need to extend the sequestration order to her. Your objection's preserved. Attorney Costa, to the extent you join in the objection.
I'm joining the objection, Your Honor.
And you have a standing joining of objections, if you wish, all defense counsel.
Thank you.
Okay, but others should be sequestered.
The witnesses are sequestered. Thank you. Now. Raise your right hand, face the Please tell me so the evidence you give the court in the case now and hearing true the truth, the whole truth, and nothing but the truth, so help you God.
Yes, I do.
Thank you.
Good morning, Mr. Lally. In a loud, clear voice, could you please state your name, spelling your first and last name for the record?
Sure. Adam Lally, A-D-A-M, last name L-A-L-L-Y.
And what do you do for a living, Mr. Lally?
Assistant District Attorney with the Norfolk County District Attorney's Office
And how long have you worked for the Norfolk County District Attorney's Office?
since 2005.
20 years?
Yes, almost.
What did you do before you worked for the Norfolk County District Attorney's Office?
Started with the District Attorney's Office straight out of law school. Worked a couple warehouse jobs, things like that during.
Sorry,
I worked a few warehouse jobs, things like that during law school. Went to school at night.
okay. And what school did you go to?
Suffolk.
Suffolk Law?
Yes.
And undergrad?
Undergrad, I went to the University of Southern California.
Okay. And what was your well, at some point, how long were you in the office before you got assigned to the homicide squad? Oh, homicide unit, I'm sorry.
I'm not sure that it's an assignment to the homicide unit. I would say the first homicide that I had outside of the realm of motor vehicle homicide was probably 2015, somewhere in there.
Okay. And let me back up a little. What type of training did the Norfolk County District Attorney's Office offer you in order for you to be able to comply with Rule 14 discovery?
Objection.
Sustained.
So when you started at the Norfolk County District Attorney's Office, you started in district court?
Yes.
Okay. And how many district court cases would you say you tried?
I have no idea. A lot.
More than 100?
Probably.
Okay. And in all of those cases, were you able to comply with Rule 14 discovery and turn over the discovery that was required under Rule 14?
Objection.
Sustained.
Let me ask you this. The hundreds of cases that you tried in district court, was there ever any allegation that you didn't turn over information?
Objection.
Overruled.
No.
Okay. And then at some point you moved to Superior Court. When was that?
Began working on Superior Court cases probably in 2006, full-time assigned to Superior Court in 2012.
Okay. When you say full-time assigned to Superior Court, what does that mean?
So what that means is during the interim period from 2006 to 2012, I had cases in Superior Court, but I was primarily assigned to the District Court.
So you were trying cases in the Superior Court, but you were still trying cases in the District Court?
Correct. Actually, I still do that to this day.
You still try cases in the District Court as well?
I do.
Okay. But you said at sometime in 2012, you were assigned to the Superior Court. Does that mean you came here every day?
Correct.
Okay. And what type of cases were you assigned in 2012 when you became a Superior Court DA?
Variety, pretty much ran the whole gamut. Narcotics cases, sexual assault cases, child abuse cases, breaking and entering, armed robbery, whatever I was assigned, that's what I did.
How long after you got to the DA's office did you start trying what they call light felonies?
I don't understand the line of inquiry. Everybody who is in the DA's office is responsible for complying with Rule 14 and is expected to know the confines of Rule 14 and to comply with it. So the backstory here is not particularly useful. What I want to know is what ADA Lally did in this instance.
Understood, Judge. In any event, when were you assigned to the Myles King case? And Brianna Gardner, I'm sorry.
Probably within a day or two.
A day or two of what?
Of the shooting and the murder occurring.
Okay. And how do you get assigned in the district attorney's office? Do they email you? Do they call you? How do they do that?
Objection.
Overruled.
I received a call from the first assistant.
And who would that have been at the time?
At the time, that would have been ADA Lynn Beelan.
Okay. And did she tell you you were assigned to this homicide case?
Yes.
And what does that mean to you, being assigned to a homicide case? What does that mean?
Well, I mean, at that point, it was an investigation. So as far as assisting with the investigation, should charges arise, handling the prosecution from there out.
Okay. So once you get assigned to the Myles King, Brianna Gardner case, is there a policy within the Assistant District Attorney's Office in Norfolk County on how to gather information that's required under Rule 14?
Objection.
Overruled.
A specific policy, not that I'm aware of, no.
Okay, so there's no policy that you're aware of in the DA's office that, that details how to gather information. Is that what you're saying?
Not that specific to that, no, not that I know of.
So how do you gather information, and how did you gather information in the King-Gardner case that was required under Rule 14? What did you do?
Objection, just specify what is, it's too vague.
Overruled. Question is, what did you do?
So what I do...
And I think we can take it in chronological order. We'll start at the beginning, and then we'll have follow-up questions.
Sure. So what I do is what I do in every case, depending on how many different departments are involved. In this case, there was a local department and state police involvement, so I would make appropriate requests for any and all information that they had, any information that, you know, specifically I could outline or delineate as far as what I felt was relevant. And
Stop right there. How would you make those requests?
Typically what I would do is write out a formal discovery request, submit the form to any involved departments, and communicate either via phone or email to whoever the relevant party was that I was requesting discovery from.
When you say discovery forms, what do you put on? What did you put on the form in this case for Gardner and King?
Initially, it would be for any and all police reports, any and all photographs, any and all information as to who was present, lab reports, if they had access to fire department, run reports, any lab personnel that responded to the scene, you know, so that I would have an idea as to whether or not there was testing that was going to be conducted or items have been recovered from the scene, copies of any and all search warrants, including applications, affidavits, copy of the warrants, any returns.
And let me stop you there. Do you have a memory in this case of asking for all the information that you just told us you normally ask? Did you do that in the Brianna Gardner and Myles King case? Did you ask for all of that information?
Yes, and just for clarity purposes, when I'm initially doing this, it's not the Myles King and Brianna Gardner case.
It's just an investigation.
Correct.
Okay.
Well, and more to that point, Ms. Gardner didn't become a focus of the investigation until later on.
Okay. So while you were investigating without a defendant being a suspect, at least not initially, you asked which departments for this information?
The State Police, Norfolk County Detective Unit, as well as the Milton Police.
I can't hear you. What was the last one?
Milton Police.
Milton Police. Okay, so you asked Milton Police, you asked the State Police. Who in Milton Police did you ask, and who in the State Police did you ask to send information?
The Milton Police would have been, at that time, Lieutenant Michael Collins. The State Police would have been Trooper Michael Proctor, as he was a case officer, and Lieutenant Brian Tully.
And so you have emails going to all three of them asking for all of the information that you just listed, which would be normal information that you'd ask in any case after a homicide. Is that right?
Yes.
And let's just take Mr. Proctor, Trooper Proctor, did he respond to you?
Yes.
And what did he provide you?
At varying...
No, to the extent he recalls, he can testify.
So at varying times, there were different productions of material, whether it was what was available at that time. So initially it would have been just whatever reports were available at that time. Later on would have been photographs, video.
So how often would you say you emailed or communicated with the State Police, and specifically Trooper Proctor or Trooper Tully, regarding discovery in this case?
I cannot tell you how many times via email, but I mean, it was a constant conversation, particularly throughout the grand jury process as far as discovery was concerned.
Okay. So when you say a constant process, was there a time period where you asked for stuff and you didn't get it, so you were re-asking for it, or is it always new information that you're getting from the State Police?
I think it would vary. I think there were certainly items that I probably had to ask for more than once, but there were definitely items that I had asked for and was provided promptly, and then moved on from there to either additional information or that avenue was complete.
So do you keep records of, I asked for search warrants, I asked for crime lab stuff, I asked for witness statements? Do you keep records when you receive that information to be able to check off to say, I got these things, they're no longer outstanding, and the rest of this is?
I mean, I keep records in the sense of a list of items I'm looking for, and obviously when I receive something, then yeah, that would get checked off the list as far as I'm not looking for that anymore because I have it.
Okay. So if you got a set of grand jury minutes from a witness that you know testified in front of the grand jury, you'd check that off your list?
Well, as far as yes, I mean, I was at the grand jury, so I know who testified at the grand jury, but as far as receiving the minutes, yes, I'm aware of the dates, and when I received the minutes, then that would check that off the list.
I missed, I think, a question and answer, one question earlier. I think the question was, do you keep records of what you requested? What was your answer to that question?
So records as far as what was requested, I would always have at least in some form, some sort of running list of items I was looking for. And then if I received an item, then that would be something that would be off the list. Now that list would be obviously added to as information develops, and there might be additional items that I'm looking for.
And presumably because it's on the list, you've made the request?
Yes.
Okay.
And so you'd have, whatever's on the list, you'd have emails requesting that information, is that right?
Yes.
Okay. And then if they emailed back, you'd have checks off of your list that you got whatever it was, that, you know, maybe you were asking for 10 things and you got 5. You'd check those 5 things off your list, is that right?
Yes.
Is there any other mechanism you used to document what you got from, just right now we're talking about the state police, Trooper Tully and Trooper Proctor?
I'm sorry, any other mechanism of doing what again?
Keeping track of what they're producing for you. Is it all just emails and check marks on a list? Or is there some other way that you keep track as well?
No, I mean, it would be something that I would have a list of items that are outstanding that would be, you know, followed up on if they hadn't been received at that point, and then I would follow up with whoever the appropriate person was to get copies of those.
And these lists remain in the file? Your lists with the check marks remain in the file?
To the best of my knowledge, yes.
Okay. And have you reviewed any of them before you testified here today?
No.
Okay. Is there a reason you didn't review the file before you testified here today?
I don't have the file.
You work for the DA's office, right?
I do.
And it's in the DA's office, right?
Yes.
And you knew you were going to be asked questions about this case, right?
Yes.
And you didn't do anything to educate yourself about what you did initially on the case?
Objection. This is her witness.
Well,
Counsel's witness.
I'm not sure I agree with that as an objection, but I'm going to sustain the objection as to the relevance. He did not review the file. Next question.
So what did you review in preparation for your testimony here today?
I reviewed portions of the file. I reviewed some of the items that have been produced by ADA Hickman. I reviewed search warrants. I reviewed police reports. I reviewed, you were asking specifically as far as checklists or notations. I didn't review those, but I did review, I have portions of the file. I have access to the file, and I did review portions of the file.
Okay. So you did review portions of the file, is what you're saying now?
Oh, yes.
You just didn't review your checklist?
No.
Okay. Now, in terms of the Milton Police Department, do you also have emails going back and forth to the Milton Police Department asking for certain documents?
Yes.
And who in the police, would that be Lieutenant Collins?
Yes.
Anyone else in the Milton Police Department were you looking for documents from?
On this case, I don't believe so, no.
And did you keep the same type of list that you kept for the state police of outstanding things that you were looking for the Milton Police Department?
Yes.
And what did you get back from the Milton Police Department? Do you remember?
Items of similar nature that they had access to as far as police reports, photographs. I don't believe Milton did any of the search warrants in this case, but other items of discovery, video that they recovered, that there's a litany of different items.
A litany of different items? Did you
Yes.
say? Okay. And those would all be memorialized by email? Is that how you did it?
Yes, that's, I think, what Mr. McGee attached as Exhibit 1. It's about 137 pages.
Of emails back and forth between the Milton Police Department and you?
Correct.
And so at what point do you know that you have all of, so other than, strike that, Milton Police, State Police, any other person or entity that you sought information for in this case?
Certainly.
I'm sorry?
Yes.
Who's that?
Be the Office of the Chief Medical Examiner, be the State Police Crime Lab. There were some items that were outsourced to Bodie Technology Lab in Lorton, Virginia, where they did some additional forensic testing pursuant to DNA. They have different methods that our lab does not. Milton Fire Department, I believe Fallon paramedics were involved in the transport of the victim, Mr. Simmons. That's all I can think of at this point.
Okay. And would you communicate with those agencies the same way you communicated with the state police and the Milton police via email?
For the most part, could have been a phone call on some of those
All right, so let's stop
issues.
there. If there was a phone call, how did you memorialize what you requested and what they said in a phone call?
Notes?
You have individual notes.
Yes,
And where would those notes be right now?
in the file.
Okay. So do you keep like a running page of all the notes that you've taken in the case with communications that you had with all of the other entities and officers in state police in this case?
Not all in one location, but it would be sort of divided up by different entities as far as what I was requesting from that specific entity and what I was looking for, what I was still waiting for, what was still outstanding, things of that nature.
Okay. So what happens when you ask for something, let's just say from the state police, and they don't give it to you? What's the next thing you do?
The next thing I do would be to ask for it again.
Okay. How many times do you ask for it before you have a meeting with the state police to look at their file?
Objection. The biggest objection I have here is that we're not speaking about any individual document, any individual date, vague questions about
Yeah, this is general practice,
General practice.
generally Mr. Lally's practice. I think part of the issue here is we don't have very specific items that are being referred to.
Right.
But I think I'm going to overrule the objection and give Attorney Scapiccio a little bit of leeway here in terms of general practice.
So in general, how many times do you email for the same document before you go to the state police and start to have a sit down with them?
I think it varies. I think it would be depending on a lot of different factors as far as what the item is, what the explanation is for why I don't have it yet, whether it's not available or whether it's something that they're currently working on, or if it's something that I know has been completed and I've asked for it multiple times and I still don't have it. I'm not saying that even happened in this case, but if in a general practice, if that were something that were going on, then yes, I would want to sit down with somebody and figure out exactly what's going on.
Okay. So let me ask specific questions about this case. When you reached out, let's start with Trooper Proctor. In this case, looking for information, and there were emails back and forth. Were there any occasions where you did not get the documents or the information that you were seeking from Trooper Proctor?
I don't recall anything specific other than if it was a situation where I'm looking for a report about something and that report hasn't been completed yet or that item hasn't been obtained yet for whatever reason. But I don't recall in this case ever asking for something and just not getting it.
Do you remember asking Trooper Proctor for the search warrants that he did in this case?
Yes.
And the affidavits accompanying the search warrants?
Yes.
And did he provide them to you?
What I received was a partial affidavit for search warrant.
Stop there. Did he provide them to you, yes or no?
Some.
How many search warrants do you recall there being in the King Gardner case?
In 2021 or beyond?
Let's start with 2021. How many search warrants? You guys pulled the search warrants?
6.
6 search warrants. Did he, when you asked, and he signed all 6 search warrants, is that fair to say?
That's my understanding, yes.
Okay. And so when did you ask Trooper Proctor for the search warrants?
In July or August of 2021 when they were filed for.
Okay. And when did you get all 6 search warrants from Trooper Proctor?
I didn't get all 6 search warrants from Trooper Proctor.
You did not?
I did not.
Okay. So did you get 1 search warrant from him?
From him specifically, I received a portion of the affidavit for search warrant 306 and the entire affidavit for search warrant 348.
Okay. So you got portions of 2 search warrants, and you knew there were 6 search warrants, is that right?
Yes,
Did you make notes somewhere in your file, geez, I asked Trooper Proctor for these 6 search warrants, and he hasn't given them to me yet?
I believe, yes.
Okay, those notes are in your file.
I believe so, yes.
Okay. And then when you didn't get the search warrants from Trooper Proctor, did you meet with him?
Yes, I mean, specific to that, I don't recall any specific meeting related to search warrants, but we did meet several times in relation to this investigation in this case.
But you understand that search warrants are Rule 14 automatic discovery, right? And you knew there were 6 search warrants, right?
I did.
And so when do you realize that you don't have all 6 search warrants? How long into the process? Do you know right away you don't have them all? Or do you not know for a long time you don't have them all?
I don't think I realized at that time that I didn't have them all.
So how, then I guess I'm confused about how your system works. You said you had a system where if you asked for something and you didn't get it, you would then follow up with the police officer asking again and again. Did you do that with Trooper Proctor in this case with the 6 search warrants?
Yes, I believe so.
How many times did you email Trooper Proctor asking for the 6 search warrants?
I don't know.
More than 10?
I don't believe so, no.
Okay. How far in between each email? Did you wait a month and email him again? Did you wait a week? Did you wait a day? How long in between your requests to Trooper Proctor to produce the 6 search warrants in this case?
I don't know.
You don't?
No.
Did you review your emails before you came here today?
Some of them, yes.
Did you see any emails to and from Trooper Proctor regarding the search warrants?
Yes.
How many did you see?
I don't recall.
More than 5?
Yes.
More than 10?
I don't know.
What are the dates of the first time you asked Trooper Proctor for the search warrant?
Specific date, I don't know.
How long before the next time you asked him for 6 search warrants?
Specifically, I don't know.
Was it months or weeks?
Weeks.
Weeks later. Okay,
Yes.
so that's 2 times you asked him. What about the third time? How much time went by?
I don't know.
Months or weeks?
I don't know.
What about the 4th time?
Again, I don't know how many times and I don't know specific dates.
So I guess my question is, how does your system work if you're not getting the discovery that you're asking a police officer for, and you're asked for it, let's just say 5 times? What do? Do you go to the office and you sit down and say, give me these search warrants, I have to turn them over?
Yes.
You did?
Yes.
Did you do that in this case?
Yes.
You go to Trooper Proctor and say, give me the search warrants because I have to turn them over.
Yes.
When did you do that?
Sometime prior to the defendant's arraignment in December of 21.
November of 21, did you say?
December of 21.
December of 21. So when you get to his office, do you go there or do you tell him to come to your office? I don't know how that works.
Either way, I don't
Remember
remember.
how you met about the search warrants the first time?
In
other words, did he come to you or you go to him?
I don't know.
Okay. So you have a sit down.
Yes.
And you ask him for the 6 search warrants, and what does he say?
He will get them to me.
He will get them to you.
Yes.
Okay. If you tell him I have an obligation to turn this over because it's Rule 14 discovery, I need it right away, I've asked for it 5 times, what's the deal?
Those specific words, no, but the gist, yes.
Well, tell me what you said specifically.
I don't know.
Well, give me a best estimate of what you said to Trooper Proctor after you asked 5 times
Objection.
search warrants that he didn't turn over.
Sustained.
So, did you keep any notes of your conversations with Trooper Proctor when you were asking for these 6 search warrants that he didn't give you?
No.
Why not?
It was something that I knew that was outstanding. It was something that I had asked for in written form numerous times. I didn't feel the need to write a note that I asked for it again.
So that's the first sit down. Did you send emails after the first sit down saying, hey, you promised me you're going to send these 6 search warrants, I still don't have them?
Objection, assuming facts.
Overruled.
I'm sorry, could you repeat the
Did you
question?
send another email to Trooper Proctor after you had this sit down at sometime in December of 2021 saying, hey, you still didn't send those 6 search warrants, can you send them over?
Yes.
How far after Mr. King's arraignment in December of 2021 did you send that email to Trooper Proctor?
I don't know.
Was it a year?
I don't think so, no.
What do you think? What's your best estimate of when you sent that email after you sat down with Trooper Proctor?
I would say probably a few months later.
All right, a few months.
Yes.
So February, March of 2022, is that what you're thinking?
I don't recall specifically.
So when you're in this room with Trooper Proctor asking about the 6 search warrants, do you ask him for his file? Like, give me your whole file so I can go through it and figure out what's in it?
No.
Why not? You're there. There's outstanding discovery. You have the obligation, not the police officer. Why don't you ask?
I entrusted that whatever discovery I was requesting, I would get at some point in a timely fashion and then turn it over.
But you didn't get it. You asked for it 5 times. You didn't get it. You had to go see him. You have him right there now, and you still don't say, give me your file? Let me go through it?
No, I did not.
And when he says you'll get the search warrants, I'll send them to you. Did he have them? Did he have copies of the search warrants? He just wasn't giving them to you?
That I don't know. You'd have to ask him.
Well, you don't get the search warrants in any event after that sit down, and you send another email. What's Trooper Proctor's response to that email?
Again, I don't know that I sent another email, but I know that there were subsequent conversations about it. Whether it was what format it was in, I don't know.
Okay, and at this point, you have to be getting a little upset with Trooper Proctor that you're asking for information that he's not giving you, right?
Objection.
Overruled.
I'm sorry, your question again?
You have to be getting a little upset at Trooper Proctor that you're asking him for information that he's not giving you, right?
I wouldn't say upset, frustrated probably.
I'm sorry?
Frustrated probably.
Oh. Judge, can we approach sidebar just briefly? I know.
Sure.
In any event, ADA Lally, a couple of months goes by, you still don't have the 6 search warrants. What do you do?
I don't know. I mean, I specific to the 6 search warrants, I don't recall as far as there was a topic that was discussed repeatedly. Obviously, I never received them because I never provided them to you or to Ms. Costa.
Okay. So I guess what I'm saying is you knew they existed, and you knew that, let me just say this, you knew that all 6 search warrants existed. Is that right? Yes,
we went through all six of the search warrants on the last day of the grand jury presentation on November 19th, 2021. That's in the grand jury minutes as far as going through each of the materials, each of the search warrants, that they were search warrants, how that material was obtained, and the material that was returned in response to 3 of the search warrants was marked as grand jury exhibits 33, 34, and 35.
Right, but not the search warrant.
Correct. Well, no, actually, I'm sorry.
Information in front of the grand jury about 6 search warrants that you hadn't seen, and you put returns or information that had been returned in front of the grand jury on search warrants you had never seen.
So with
Answer that question.
And I'm trying to. So
okay.
With regard to those 3 search warrants, that was 306, 307, and 329, which were the call detail records for your client, the victim, Mr. Simmons, and Mr. Jeanette. The materials that came back from the cell phone providers also contained a copy of the warrant, as well as the addendum to the warrant, which was then also provided to you and Ms. Costa in discovery.
But not the warrants themselves.
No, the warrants themselves and the addendums, not the application and not the affidavit.
Right, so you understand that in order to make a determination as to whether or not you're going to suppress certain information, you actually need what you asked for and what you, in the affidavit that told the clerk magistrate why you had probable cause, right?
Objection.
I can take judicial notice of that, and I'm sure Mr. Lally knows that.
Okay, so you get in front of the grand jury. When do you present this case to the grand jury?
Began in July of 2021. That grand jury sat in July, August, and September. The presentation had not been completed at that point, so there was a motion to extend the grand jury. And I believe there was one subsequent date that we went before them on November 19th, 2021.
November what?
19th, 2021, that's when indictments were returned.
In 2021?
Correct.
Okay. So at some point when Mr. King is arraigned, you understand at that point, Rule 14 kicks in, right?
Yes, I mean, I'm thinking about Rule 14 well before that.
Okay. And you know, when you arraign Mr. King, you still don't have the search warrant. You have another conversation with Trooper Proctor about, hey, where are these search warrants? I have to turn them over?
I'm sure I did.
And do you know when that would have been?
I don't.
Okay. And then, remember at some point in December of 2021, receiving a discovery notice from me. Hey, First Witness, Your Honor.
Yes.
This is just my discovery notice.
Is that a discovery motion, or what is
Motion,
that?
I'm sorry, motion, Judge.
Yes.
Okay. And do you remember, after having filed this motion, you asked the time to go through and make sure that you can comply with all the requests, right?
Yes.
And you didn't have any specific objections to anything that I was asking for, right?
At that time, no.
Okay. May I approach the witness, Your Honor?
Yes.
Sorry, Judge.
Is that an exhibit? Is that a docket entry?
It is a docket entry, Judge.
Do you know what it is?
I think it
Or we can mark that just so that there's a record of what you're showing the witness?
has my writing on it, Judge. So
All right,
I want to
so-
mark it. But I'll do it after the hearing. I'll find the exhibit and I'll make a clean copy and send it to the court, Judge. So once you get the discovery notice, you know for sure that there are certain categories of information that we're looking for, right?
Yes.
And number one is all automatic mandatory discovery under Rule 14, right?
Correct.
Would you consider those search warrants automatic mandatory discovery under Rule 14? Okay. And we were looking for any and all statements of witnesses, is that right?
Yes.
And we were looking for all exculpatory information, whether
The
tangible...
document speaks for itself.
Okay, that's fine, Judge. So after I filed this motion to December of 2021, you have another conversation with Trooper Proctor saying, give me the 6 search warrants.
I'm sure I did. My general practice is if there is any discovery motion that's filed by counsel, what I'll do is I'll send that to the appropriate police personnel as far as making requests and making sure that they're apprised of what's been at least asked for.
Excuse me, and did you do that in this case? Did you send my motion for discovery to Trooper Proctor, to the Milton Police, to the crime lab, to the medical examiner's office? Did you send it to all of those entities?
Every motion that you filed, yes.
Okay. And then what do you do to follow up with each of those entities? Let's start with the state police. They get a copy of my discovery motion. You're looking for all of the evidence that they have, and specifically these 6 search warrants that, for whatever reason, Trooper Proctor hasn't given you. When you follow up, how long does it take you to follow up from the time that you give them the motion until you get an answer from them?
Specifically, I don't know. Typically, I would give it a couple of weeks or so.
And after a couple, and in this case, did you give it a couple of weeks, you think?
Probably.
Okay. And then what happens?
And then I'll follow up again.
When you say follow up, do you send another email, or do you get in your car and drive down there and say, we got to end this, give me this stuff?
I email or a phone call.
Okay. And so did you email or phone call, or make a phone call to Trooper Proctor in this case?
I'm sure I did.
And what was his response?
I don't
When you
recall.
asked for the 6 search warrants?
I don't recall.
Well, do you have any notes of your conversation with him? Remember you taking notes?
I don't believe so, no.
Is there a reason that you didn't take notes when you spoke to Trooper Proctor after these search warrants had become an issue? That you wouldn't take notes of what Trooper Proctor told you about the search warrants?
So you're asking me about a conversation that I don't recall specifically when it happened or exactly what was said. So whether or not I took notes for that conversation, I don't know. What I would do typically in my general practice is to follow up with whoever I had outstanding discovery requests in relation to try to get whatever information that I was seeking.
Okay, and so did you follow up with Trooper Proctor about the 6 search warrants?
I'm sure I did, amongst probably a number of other items.
Okay, and then you knew this case was going in for another date on discovery, right?
Yes.
And you knew you'd have to answer to the court what you've provided and what's outstanding. Isn't that typically how it goes on discovery dates?
Yes.
Did you ever tell the court, geez, like I have these 6 search warrants that Trooper Proctor has, I can't get my hands on them, can you issue an order or can you help me out here?
Did I do that? No.
So when you went to court, do you remember representing to the court that discovery was ongoing and that you were producing as much information as you could? Remember that?
Typically, that's what I would say if that was the case, yes.
Okay. But you knew when you represented that to the court that you didn't have the search warrants, right?
Yes.
So what was your plan? How are you going to get them?
As I stated, what my practice would be if there was some outstanding item of discovery, I would request it and follow up if I hadn't received it.
But you did that. You requested it 5 times. You went to see him. Then you got my discovery motion. You sent that to him. You waited another month. And then what happened?
I don't recall.
Well, don't you tell him, get me these things now, I'm coming down your office?
Objection.
Overruled.
Did I ever tell him that? No.
Okay. So what do you do when he's not complying with your request? Let me ask you this. What's the policy in the office of the District Attorney's Office in Norfolk County when a state trooper is not complying with a request for discovery?
Objection.
Overruled if there is a policy.
What's the policy?
I don't know any specific policy related to that.
Okay. So do you go to your supervisor then and say, hey, I've asked Trooper Proctor 5, 6, 7 times for these search warrants. I've been down to see him in person at least once. He's not giving them to me. What do I do?
No.
Did you ever have another case other than Mr. King and Ms. Gardner's case where a state trooper didn't give you search warrants that you had been asking for since before indictment?
Objection.
Overruled.
Not that I recall, no.
Okay.
Your Honor, may I be heard on one slight issue? The discovery, the discovery request the counsel is speaking to, I don't believe that it was ever docketed. I don't have a copy of it. I've never seen it. So
The motion, the motion?
Motion for discovery was filed. He got.
Well,
it may not have reached the docket, as I guess.
I want to make sure that you see it, though. Let's make sure you...
Speaking about it a lot here, and
No.
I've never seen it.
Attorney Scapiccio, can you just give it to Mr. McGee for a second?
Sure. You think it would be in the file?
I would think it would be in a file. Is that a clean copy?
That is a clean copy, Judge.
Can we mark that? Should we mark it?
It's unsigned, and it's probably, I don't know if it's a draft or a,
Oh, the non-signed, all right, so let me get you a signed copy, Judge.
I don't know what was.
The bottom line is, this witness said he received it, Judge. I know I wouldn't have not filed it. We talked about it in the hearing. And I think there is a transcript, Judge, of a hearing where we talked about the discovery motion, and the court had it.
All right, we'll
In front of it.
figure that out.
Can you guys put the transcript?
We do have ADA Hickman did have a copy.
You do have a copy?
I never saw it on the docket. I was working right off the docket.
Okay.
So,
And just so the record is clear, we have marked it? You want it marked as Exhibit 1 in this hearing?
yes, Judge.
Sure.
All right.
Get you a signed copy, apparently.
All right, that will be Exhibit 1.
Thank you. I'd also, at some point, Judge, like to mark the pretrial conference report, in this case.
Thank you.
So this had never happened to you before, Attorney Lally, and you didn't go to Lynn Beelan, who was your supervisor, and ask her what to do. What was your plan? How were you going to solve it?
I don't recall specifically having a plan. If there was a situation where I was asking a trooper or a case officer for something and I had not yet received it, I might get that person's supervisor involved as far as saying I've asked for this a few times, I don't have it.
Okay, so let's stop there. Trooper Tully was Trooper Proctor's supervisor, is that right?
Yes.
Did you go to Trooper Tully and say, hey, I don't know what the deal is, but I can't get these 6 search warrants from Trooper Proctor. Can you have him send them to me?
Specifically about the search warrants, I don't recall.
You didn't go to a supervisor.
I don't know if I did or I didn't.
But as you sit here today, you don't remember going to a supervisor, is that right?
I know that there were a number of meetings in relation to discovery that Lieutenant Tully was present for, along with Trooper Proctor, but going specifically to his office to demand 6 search warrants, I don't recall that.
Okay. So how much time goes by before you ask for the search warrants again?
I don't know.
Is it a year?
I don't know.
During the time period, it's fair to say that we were appearing in court every couple of months on discovery, right?
Yes.
Did you ever notify the court on any of those court appearances that you were having trouble getting custody of the 6 search warrants that were issued in this case?
No.
Okay. Now, you talked about having meetings, discovery meetings. Tell us what those are.
You know, at various points, probably more towards the early stages, or if there's something that's significant that comes up, it would be just a meeting in relation to, this is the discovery that's outstanding, this is what I'm looking for, what's the ETA on this, when should I expect to receive this?
And are those meetings in person or on the phone?
Typically in person.
And do they take place at the DA's office or at the state police?
Well, I mean, in this specific instance, the state police is attached to the DA's office, so it's the same building. So whether it was my end of the hall or their end of the hall, I don't know.
Okay. And do you remember discussing the search warrants and the outstanding nature of the search warrants at the first discovery meeting?
Yes.
And what was the response?
That the search warrants are still ongoing, as some of those search warrants were not just July. I believe it continued into probably September of 2021 as far as the last of the search warrants. I could be off on those dates, but
so how many motions or how many meetings do you have regarding discovery before the return of the search warrant in July of 2021, if that's the date?
not many. I mean, I mean, the murder occurs on July 10th, so there's not a lot of time in between that. So probably 2 at the most.
2, okay. And you don't take any notes on those meetings either?
I don't know.
But I guess I can't figure out, how do you keep track? If you have this list that says all these things are outstanding and you're having these meetings because there's things outstanding, if you're not taking notes at these meetings, how do you know what people are saying and when to expect the discussion?
So if there was something that specifically was known as far as, you know, this is what's going on with this piece, and anticipated sort of ETA on return or something, then yeah, there would probably be a note about that.
All right, so let's assume that the returns came back the latest July of 2021. Let's give you 3 months, August, September, October. October of 2021. Are you asking again for the search warrants that you still don't have?
We've been over this time period. I'm trying to figure out you went all the way through arraignment and on the number of meetings and emails back and forth. I get it, but maybe you want to cover new ground.
I'm just trying to figure out, so let me ask a question. So when do you realize that you never turned over the search warrants? When do you realize that?
As far as the 2021?
Back up. When do you get the search warrants in your custody?
In my custody?
Yes.
I would say probably I became aware of it about a month ago.
In 2025?
Yes.
July of 2025 or June of 2025?
Yes.
Is the first time you became aware that you didn't turn over the search warrants?
Yes, if I had been aware earlier, then I would have turned over the search warrants.
But you had your list, right? You had your list that said 6 search warrants outstanding, right?
Yes.
You didn't ever check that off, right?
No.
So you knew they were outstanding, right?
Yes.
Okay. And then when did they get to your file?
Again, so as far as my file, they did not. Again, I became aware of it after the case had been transferred from myself to ADA Hickman.
Well, let's talk about that. What date was the case transferred from you to ADA Hickman?
I'd say probably somewhere in October or November of 2024.
2024.
Yes.
And how does the case, let me just say in general, how does the case get transferred from one DA to another? Is there a policy within the Norfolk County District Attorney's Office of what needs to get done to transfer a file?
No policy, no.
Okay. So what did you do in this case with Mr. King and Mr. Gardner to ensure that your complete file got in the hands of ADA Hickman?
So I physically took the physical file from my office to ADA Hickman's office.
Okay. And do you have a conversation with her?
Yes.
And did you tell her, hey, there's 6 search warrants that I was never able to get from Trooper Proctor?
Again, if I had known or remembered that the 6 search warrants were still outstanding, then I would have got them and provided them. So no, I did not reference that specifically.
But then at some point, ADA Hickman has to come back to you and say, did you not turn over these 6 search warrants? Say that to you?
No.
She never did.
Nope.
Did you ever have a conversation with ADA Hickman about the outstanding 6 search warrants?
Not until recently, no.
Okay, and what transpired?
Objection.
Sustained.
Well, so when you told the court that discovery was almost complete, did you know when you made that representation that the 6 search warrants were still outstanding?
Objection.
I don't know what time frame we're talking about.
I also, as I've stated in my opposition, I've reviewed the FDRs on this from December and February and the other dates in 2025. That statement was never made. So,
That's
and then
why I want a
December
date. That's why I want a date.
and October as well, when Your Honor set this for trial. So thank you.
So when's the last time you remember answering on this case?
I believe it was December of 2024.
Could it have been January of 2024?
January 2024?
Oh, so let me back that up. In January of 2024, were you still representing the Commonwealth?
Yes.
Okay. And do you remember there being a hearing regarding discovery?
Not specifically, but I'm sure there
Okay.
were.
And do you remember, excuse me, do you remember the court asking about discovery and how the discovery was proceeding?
I'm sure it happened. I don't recall that specific date or what was asked.
Okay. And do you remember telling the court in January of 2024 that you were hopeful that by March of 2024, we could proceed forward because discovery would be complete? Remember that?
I don't.
Okay. May I approach the witness?
Yes.
It's from when? That wasn't able to.
January of 2024.
I know. Show you the request. Okay.
May I approach the witness?
Yes.
I'm going to give you the transcript of the appearance before this court on January 24, 2024, and ask you to look on page 5 and tell me, read that, the bottom of page 5 to yourself and the top of page 6.
Yes.
Does that refresh your memory as to whether or not in January of 2024, you told this court that substantially discovery was complete? There might be 1 or 2 items that are outstanding, but can we get them to us?
I didn't read that portion. I was reading the highlighted portion, if I could have a moment.
Sure.
I'm sorry, I'm not seeing what you're referring to in that
Well, do you remember
transcript.
telling the court, Your Honor, I think as far as discovery goes, we're in a fairly good position. Did you say that to the court?
I may have.
Look at lines 16, 17, and 18 on the document that's in front of you, Ms. Lally.
And what page, Ms. Attorney?
Page 4, lines 16, 17, and 18. The court asks, where are we, Ms. ADA Lally? And you say, Your Honor, I think as far as discovery goes, we're in a fairly good position. Did you say that?
Again, I'm sorry, in the transcript that you handed me, I don't see that.
Let me see, it's a different one. Do you remember, hold on, let me get this right. Do you remember telling the court, I was wrong, you were right. Do you remember telling the court there may be a couple of outstanding pieces, talking about discovery, that I'll check on, and some other pieces that I was speaking to Ms. Coster about, but I think hopefully that by March 11th date, we should be able to proceed forward. Remember saying that to the court?
Do I remember saying that to the court? No. If
Does reading that refresh your memory that you said it to the court?
I didn't read that portion, on what page are we on?
Yes.
You can read from here over to here,
Okay.
to yourself, please.
Sure. Yes, that's correct.
Does that refresh your memory? Maybe a rally that you indicated to the court that, get this exactly right, there may be a couple of outstanding pieces that I'll check on, and some other pieces that I was speaking to Ms. Coster about, but hopefully by the March 11th date, we should be able to proceed forward. Did you say that to the court?
Well, those are two. So does it refresh my memory? No, but according to that transcript, that's what I said, yes.
Okay. And you know at that point that there were still 6 outstanding search warrants that you didn't have?
No, again, if I had known, then I would have gotten them and provided them.
Okay. But weren't we talking about search warrants on this day?
You're talking about 2022 search warrants, which were in a subsequent notice of discovery related to a cell tower dump. You were provided all of those as far as the application, the affidavit, the return, and copies of the warrants themselves.
So we're talking about search warrants,
Separate search warrants, yes.
and nothing's ringing a bell that you didn't turn over 6 search warrants?
Apparently not.
Okay. So the 2022 search warrants that we talked about in court back on January 24th of 2024. At that point, Mr. King was indicted, is that right?
Yes.
Was Ms. Gardner indicted?
Yes.
All right, so what process did you go through to issue the 2022 search warrants after indictment?
Through this court.
I'm sorry?
Through this court.
So you went to Superior Court and asked for these search warrants, is that right?
Myself personally, no.
Well, did you notify defense counsel that you were asking for search warrants in a case where a client had already been indicted?
No.
Do you know whether or not there's an obligation on behalf of the district attorney's office to notify defense counsel post-indictment if you're moving to request additional search warrants?
They weren't search warrants that were pertaining to the defendants. They were...
Do you know whether or not there is an obligation on behalf of the district attorney's office, you specifically, to notify defense counsel if you're seeking search warrants after indictment?
Objection. If this is a legal, yeah.
Sustained.
Thank you.
So in any event, we're talking about search warrants in January of 2024. You don't say anything about the search warrants that are still outstanding, those 6. And you tell the court there's only a few things that are outstanding then. Is that right?
Yes.
Okay. And then we come back, we suggest March, and we come back in March. Is that right?
I believe so, yes.
Okay. Then in March, do you tell the court, Your Honor, as far as discovery goes, we're in fairly good position. In regard to that, I believe that was turned over just prior at the last date, so there may be a couple of other additional items of discovery that I need to get and turn over, but otherwise, I think we're in a fairly good position. Did you say that to the court, sir?
Again, I don't.
Finish, Your Honor.
Yes. These transcripts in the FTR, what's on the FTR, what was said by whom, when, is all a matter of public record, and we can look at the FTR and get it. So specific quotes and what was said, what was represented, that's part of the record, and we can see
But I
that.
just have to set it up so I can ask the question that I want to ask, Judge.
Great.
Thank you. So after having made that representation to the court, did you do anything to get the 6 search warrants?
No.
What were the outstanding matters as far as you understood back in March of 2024?
I don't recall exactly what we were talking about on a court date in March of 2024.
Do you have any notes that would refresh your memory as to what was outstanding at that point?
I might.
And would they be in your file?
If they were anywhere, that's where they would be, yes.
Okay. Now, other than the discovery motion that we filed, did we also file a pretrial conference report in this case?
That I don't recall.
Okay. But you understand, normally we file a pretrial conference report where you agree to give me what I'm asking for, and we agree to file motions on stuff we can't agree on. Is that typically how it goes?
Yes.
Okay. And you don't remember signing a pretrial conference report? Not that you didn't, you just don't recall.
I don't recall every pretrial conference report I've signed.
Okay. And then we talked about the meeting with the state police. Did you have any meetings with the Milton police regarding outstanding discovery?
In-person meetings? No.
Did you send the Milton police the same type of discovery request that you would have sent to the state police?
Yes.
And did you follow up with the Milton police the same way that you say you followed up with the state police?
Yes.
And did you follow up specifically with Lieutenant Collins?
Yes.
And so what, in your mind, was outstanding on the Milton discovery that you were communicating with Lieutenant Collins regarding?
At what time?
Let's start at the beginning.
Again, it's the same type of information that you asked about before, as far as reports or photographs or any material that they might have pertinent to the case.
So whatever the Milton police turned over to you, would you have kept notes of that somewhere?
Yes.
Would there have been emails back and forth between you and Milton about what transpired?
Yes.
Okay. Did you have any trouble getting information from the Milton Police Department?
No.
When you asked for things, did they return your email and give you what you were looking for?
Yes.
Were there any reports from the Milton Police Department that you say you didn't have before you turned the case over to ADA Hickman?
There was one report, yes.
And what was that report regarding?
Mr. Turner.
I'm sorry?
Mr. Turner.
And what about Mr. Turner?
There was a report in the materials that ADA Hickman turned over in 2025 that was, I believe, offered by Detective Sergeant Clifford Murphy pertaining to Mr. Turner that I had never seen before.
Okay, and do you know why that wasn't turned over by the Milton Police Department?
No.
Did you go down to the Milton Police Department and look through their files?
No.
At any point in time when you were representing the Commonwealth, in this case, did you go down to the Milton Police Department and look through their files?
No.
Is that something that you would normally do in a homicide case? Go to the police officer's office and ask for the file?
At what point in the case?
At any point.
Typically, that would be something that I would endeavor to do closer to trial.
Closer to trial?
Yes.
So how could you make sure your obligation was satisfied if you're not meeting with the police until right before trial?
It's an ongoing duty and obligation that extends even beyond a trial.
Right, that's not my point. My point is, if you're not meeting with them and you're not going through their information, how do you know you've turned everything over to the defense?
Because I've requested it and I've been given assurances or information indicating that that is what they have.
Let me ask you the same question about the state police. Did you ever go through the state police file while you were handling the case, as opposed to making requests and even sitting down with the state police to make, face-to-face requests on an ongoing basis and all the follow-up contacts that you had? Did you ever actually request their whole file to go through it yourself?
No.
Okay.
And can you tell us, was there a policy within the Norfolk County District Attorney's Office of sitting down with police departments, whether it's state police or Milton Police, and reviewing their file prior to trial?
Not that I'm aware of, no.
Okay. So how far in advance of trial do you finally sit down and go through, let's take the Milton Police box?
It would depend, case to case, but it's something that I would probably do at least a few months ahead of trial.
A few months. And is that the first time that you put your hands on the actual box, or are you still dependent upon the Lieutenant Collins and other officers to give you what you're looking for?
Oh, that would be a time where I'm actually like, let me see the file and ensure that I have everything that you have.
Okay. And is there any prohibition to that meeting that you have a couple of months prior to trial happening right after indictment?
No, and that would be my practice now. So you're asking about sort of my general practice at the time. That would have been it at the time, but now I would do that much, much earlier in a case.
Okay. And the state police the same way? Did you sit down with them at some point and look through their file, or you never looked through their file?
No, as His Honor just asked, no, I didn't.
Okay. So I guess my question is, how did it work? Did they only look through their file and send you what you're asking for? Or at any point did they send you, here's everything that we have?
My request and my ask was for everything they had. So as far as me then double checking to ensure that I have everything they have, that would be something that would occur later on. And as I just indicated, my practice now would be to do that much earlier in the case.
Okay. So when you go, in this case, you knew we had picked a September 8th trial date, right?
I was aware, yes.
Okay. So you knew the case was ready for trial on September 8th. When were you planning on sitting down with the Milton Police and going through their file?
As the case was reassigned to ADA Hickman around the time that we selected the trial date, I don't know that I had a specific plan to do that. I did have a specific plan to meet with ADA Hickman to go through the file to ensure that she had everything that was there.
So by the time she had taken over in January of 2025, you had not made any plans to sit down with the Milton Police to go through their file, is that right?
She had taken over prior to that, but no, I hadn't.
Okay, and the same with the state police, is that right?
Correct.
Okay. So when you're updating ADA Hickman, when she takes over the case, do you tell her, I've never actually seen the files, it's on my list of things to do, but I never get down there, you should get down and take a look at the files?
Not that specific, but yes.
What did you tell her?
That, during the regular trial preparation or meeting with the officers as it gets closer to trial, I would do that, but I hadn't done that yet.
Okay. So I'm still trying to understand, is there like when the police give you something, do they just email it to you, or is there like a list to say, we gave Lally these documents on this date?
As far as their list?
Yes.
I have no idea what they have.
Okay. So you don't know, as you sit here today, if they have an index of all the things they say they gave to you?
I don't.
Okay. And do you, on the opposite side, have an index of the things you got from them?
It would be contained within those requests, yes.
All right, so at some point, do you print out all your requests and say, okay, let me just make sure I have everything here? I've been requesting something since, December of 2021. I want to make sure I have everything. Do you sit down and do that at some point to make sure everything you requested, you've received?
My general practice would be, yes, and that would be as I know we're getting closer to a trial date.
Attorney Scapicchio, it's a little after 11, and we're going to be able to go until about 11:10. And then I have to break because we're going to have to do the motions to suppress on the two other matters. So we need to think about an appropriate time to break. Maybe now is a good time to break, and we need to talk about another date when we can come back and continue the hearing.
So you're on.
Okay. Attorney Lally, you can step down. Thank you. For the record, I think the defendant's general motion for relevant discovery is docket number 8 in docket number 21, CR 320. That's what we were going to mark as Exhibit 1. It's signed by you, Ms. Capiccio.
It was, on behalf of Ms. Gardner.
I don't know, I didn't dig up a motion to join, but in any event, we're talking about what would be otherwise Exhibit 1. It's docket number 8 in the case, all right? Next dates. I would like to have the benefit of your comparison of the old and new, the earlier disclosed and the later disclosed, and how the various items are different.
So,
Might I ask also that the court order if they are materially prejudicial to the defendant as we explore this discovery?
Yeah, I'm not sure where your microphone is, but if you can, your mic, can you speak right into the mic?
May I also ask the court to order what is materially prejudiced that have
Right.
these materials from
Right.
us?
It would be helpful to me if you're proceeding on a prejudice argument to know what it is that you contend is prejudicially late disclosed, okay? And,
might take a little longer, Judge, because last Thursday, we got some additional discovery from the Commonwealth.
well, let's start in tranches, okay? We can deal with April, and then we can deal with May.
Okay.
And if we have to deal with it in parts, we can deal with it in parts.
So you're right.
But I don't know how much time it's going to take for the parties to get together on this, and I don't know how far out we should look at a date.
And as far as the time frame for the material, how about when counsel filed the motion? Up until that point. I'm not going to.
Mr. McGee is suggesting that which of the documents produced as of the time you filed the motion for sanctions or to dismiss,
Okay.
do you now view as prejudicial? That is to say, and frankly, how you were prejudiced, okay? This is a witness who's deceased, or we have no way of following up on this, or whatever it is, okay?
That's only part of the other, I don't want to not meet before that.
Will be.
I mean.
I would like you to do, a week, spend a week to try to get back and forth together on these.
Sure.
There's a long list, but it's not voluminous. You can deal with it. You've been through these documents. Each side has been through the documents.
Sure.
So hopefully you can come up with a list. And, I'm happy to give you a date when we can continue this hearing.
Sure, Your Honor. How far out do you think we need to go?
Well, it depends on when you can get that list together. I don't know how long it's going to take for you folks to get together, but we could do later this week for continuation of the evidence. We could do the following week, I believe, on the 29th to 30th in the morning. I'm not 100% sure.
Could I bring the other parties in? I think.
Sure.
Another ADA is drafting.
Sure.
Parties. And I know we have counsel here for another party, so.
If somebody has the transcripts of all the various hearings,
I do, Judge. I'm happy to share them with everybody.
yeah, share them with everybody and let's
Thought this to be literally late last night.
all right. But my point is, in the next hearing, stand up and say, Exhibit A is all the transcripts of the various hearings on discovery. That's Exhibit 1, okay. And Exhibit 2 is our reconciliation between the documents, and this is the way in which they're different or new, okay. And Exhibit 3 is whatever else you want. Here's our discovery report, and here's my discovery motion, and here's the motion. You don't need a witness for that. These are all part of the record, and so there's going to be no contest as to any of that. That's just putting in the record. And then if you have specific questions for somebody, ask it. But, so I think this can be done in a much more streamlined way. And hopefully we can do it that way. How much more, what other witnesses do you anticipate?
I anticipate Trooper Proctor, who didn't join us today, and I anticipate ADA Hickman. Those are the only three that I've subpoenaed, but based on the testimony, I think we're probably going to need Lieutenant Collins as well, Judge, and maybe Trooper Tully.
All right, and how many witnesses do you think you're going to need?
Trooper Tully here, Deputy Chief Collins, and Officer Benda, regarding the Milton issues. There's a motion to quash, and I know Your Honor's up against somewhat of a time with respect to ADA Hickman, being the predecessor counsel and now counsel of record on the
Yep.
case, that she can answer any questions the court can, has, that are remaining,
Okay.
from right where she stands,
All right.
and opposing the production of.
All right, so we have 4, maybe 5 witnesses left. So, we need a day, when we can do this in an efficient way. Jim, how does our calendar look?
Well, 7/29, which is a Tuesday, is
Yep.
particularly good.
Particularly good.
Well, there's
There was
nothing else on that day.
There was a reason for that.
No,
I'm
that's
trying
what I
to
was-
remember what that reason was.
Tuesday.
We have a noon lobby conference.
There is a lobby
I have
conference.
a federal case on, so.
29th is not going to work for you, okay?
How about the 30th in the morning?
We have anything on that morning?
We do not.
No?
Should we potentially push this to the first week of August?
The 30th is a problem for you?
It is, if I could have August 5th or 6th.
6th is out, 5th is a possibility, but I don't know what we have that morning.
Okay, how about,
According to me, the 5th
Seven.
isn't good. Something going on the 5th. It's blocked out.
That's blocked up. Let's just pull up the list for the 5th. I know I am not away that day.
Hector Calderon,
Mm-hmm.
the lobby.
All right, so, it looks like we could do August 5th.
just could, I know that,
Can you do that?
I can,
All right.
does it work for?
Witness issues, August 5th? That's okay? All right.
the judge could, I know that, Trooper Proctor's attorney is here. We did serve him in hand today. Could he communicate the new date, so we don't have to reserve him? I don't want to go back to his home.
Morning, Your Honor. Dan Moynihan on behalf of Michael Proctor. He can be available August 1st.
Okay, good. So, 9 o'clock?
Sure.
I would like to get, the agreed to exhibits, including, the transcripts of any prior hearings, any prior filings that you want to draw to my attention, the reconciliation of exhibits, et cetera, in advance. So, I am away the 31st and 1st. So if I have them here by first thing on the morning of the 4th, I'll read them all before the 5th, okay? So, I'm not trying to create artificial deadlines for you, but I think everything will go faster if I've had a chance to take a look at the agreed to exhibits, okay?
Absolutely, Your Honor.
All right.
Thank you, Your Honor.
Thank you, Your Honor.
9 a.m.
We'll take a 15-minute break and reconvene 11:30 on the motions to suppress.
Thank you, Your Honor. Thank you.